have been using a cooker in our home. So when our mother cooks anything, she tell that, "Beta, see when it's 3 CTs in the cooker, go turn it off." So now there has been a development in this area that according to a sound system, the cooker after 3 CTs will turn off itself. But we won't be able to protect that in India because we don't have utility model patent system in India. Same going with the example of a pressure cooker again. After cooking rice, we drain its starch. And while draining its starch, we have seen that many a times people burn their hand, or due to the steam coming out of it, we feel a lot of heat. There has been a pressure cooker built which after pressing a button will drain out all the starch from the cooker itself. So these type of products are not patented in India, but Germany made a protection system regarding it, and it was the first country that excelled in production. The second country was Japan. In Japan, this kind of patent system is called petty patent system. Japan used to be in the mid 90s to early 1990s. Japan used to be the biggest producer of all the electronic items, and it was because of providing protection to utility models. Opportunity for Chinese, as we can see, have used technologies like Android and developed by tying your broom to a stick or using a vacuum cleaner to clean every dust or every web of spider in our house. We have seen that we have done jugaad in everything. But if this jugaad will be protected in any kind of law, it would be a great help for MSMEs and small inventors to protect their inventions going further on. It was proposed in the Law Commission report in 2021 that a utility model patent system should be accepted in India also, so that the Atmanirbhar Bharat and Make in India campaign becomes successful. So what is the major challenge? The major challenge that has been seen in this system is that it will be utilized by major corporate houses. Major corporate houses in India would use this for themselves and won't let MSMEs or small investors come out and use this system for themselves. And if we excel in utility model patent system in India, the Make in India and India from being a service sector economy would convert into manufacturing sector economy. Thank you, sir. Thank you, ma'am. That was all in my presentation.
Thank you, Yashraj. Thank you. And for your information, I will tell you one thing as far as the utility model patent is concerned, particularly in Japan. I was there in Japan a week before. I went to Japan patent office also, where they were very strong on innovation friendly. At the same time, they are not compromising on the standard of patentability. But what is happening in the Japan as of now, more than 90% in Japan, they are selling the Chinese products, not the Japan. So, and only the Chinese product are there. Even as far as the utility model, the small level inventions, you can call it as either in a France or German and other places, innovation patents, you can call it. Even those aspects, the Chinese government, as far as the model is concerned, due to the stringent provision, that is an issue. But my question is there any possibility in India to apply the utility model of the world nation as it is? Because India is a country where we have a patent system, but the developed country says that it is a stringent patent system. But you have to think about it, even if it is liberalized or flexible, what would be the disadvantages also for the very object of the patent law? And do you think that utility model is one of the options for self-reliant India? What do you want to say about it?
Sir, before answering your question, I would like to have a question of my own. Sir, most of us have seen Shark Tank India, and most, I guess, many of us have would have seen Shark Tank Australia or US also.
Okay.
So, sir, there was one major difference between both the Shark Tanks. In Indian Shark Tank, everyone who used to come there to pitch in would come with providing any service to the people. And that in US, people used to come with an idea of a product that they would sell. So a major thing that I saw in the US was one product that I saw was broom, a vacuum cleaner attached to a broom. After cleaning our house, we go find a pan and then collect all the dust and throw it. And in the broom concept, after you sweep your house, it it has a button that you click and it will soak all the dust inside it, and then you throw in the dust outside. It would be convenient for us. And in the similar scale, if we go, sir, if we come to India, sir, you would have seen a school student who had made a cycle attached to a washing machine. When you will pedal it, the washing machine would run. It serves dual purpose. First is it would be good for your health, and second is it would clean your clothes. But sir, these kinds of inventions are not protected in India. If we protect these kind of invention, if a child can think of it, most of the people, when they see these kinds of protected, they would develop a mind for making products and not for providing services for any product.
Okay, okay, okay. Madam, Dr. Vichita, ma'am. Yes, ma'am. Even there is the question. Ma'am, please, I kindly request you to unmute yourself.
You are saying that in Shark Tank India, only services are being promoted in India, and the Shark Tank version of other countries like US and Australia, some products are being promoted to be sold in the market. But that is not the point. Over here, also we may find the new products, new utility products which are launched in the market, and in Shark Tank also we saw a lot many such products. And like you're talking about the new inventions of washing machine with the help of a cycle, that is a very good invention, but I think government is working for the protection of it, and the suggestion would be like as you have given, the center has given that some few legislations, specific legislation should be there for the protection of these kind of inventions.
Thank you, ma'am. If the coach has also have any questions, you may ask. Thank you, Raj.
Thank you,
Thank
sir.
you.
Thank you, ma'am.
Thank you.
Gargi.
I would like to, sorry to interrupt. An instruction for the participants. The maximum time that should be provided for each participant is 10 minutes. I would like to humbly request all of them to confine their presentation for 10 minutes. Thank you so much.
Okay. Good morning, everybody. Is my slide visible?
Now it starts screening, ma'am, please.
Yeah, it is about to, like it is starting this screen.
Okay.
Yes, ma'am.
Yeah, it's visible now.
Okay. Good morning, everybody. So now I'm going to give a presentation on implications of geographical indication on conservation of indigenous rice varieties of Northeast India. So we all know that geographical indication, actually it is an indication, it is a mark that identifies a product with some unique qualities and which has the
Ma'am, it is not audible.
I think she is having some technical glitch.
Yes, ma'am. I think she has some low band. Otherwise you can switch on your video on, no issue. Arki Sharma ma'am.
I think she is having some technical issues at her
Yes,
place.
yes ma'am. I think she.
Hello.
She has left. Again, she has joined. Yes, yes, Madam Gargi Sharma.
Uh, is my slide? Yes, is my slide visible? Ma'am, is my slide visible?
No, no,
Oh,
no,
my
it's
slide
not.
is
It's not visible.
Is it visible now? Is it visible now?
yes,
Am I
it is
audible, ma'am?
yes, you are audible.
Okay, okay. Now, if we see the statistics, then we can see that a lot of varieties have been registered till date. So, in maximum products have been registered in 2021, that is 47. But unfortunately, from northeastern region, only 33 products have been registered, and there are only 4 rice varieties. One is Johar rice of Assam, then Buka Saul of Assam, Chokwa rice of Assam, and the fourth one is Chakhao, that is the Manipuri black rice. There are only 4 rice varieties that have been registered from northeastern region. Now, if we see the importance, of GI in agriculture products, then we can say that GI is a very, very important marketing tool. We can use GI as an important marketing tool. And here we can take the help of GI-based branding. So branding is very, very important while marketing any product. So branding is very, very important, and we can take help of the GI-based branding, because whenever a GI tag is granted, and then it increases the demand in the national and international market, the producers get wider access to the market, and this actually lead to economic development or economic upliftment of the producer. But generally, what happens in case of indigenous farmers or producers in the agricultural sector? What happens? They have to offer their commodity in simple form, because they are unable to differentiate their goods to consumers in the international market or some good national market. And differentiation is very, very important to fetch premium price. So nowadays, what happens? Our farmers are mostly interested to cultivate the high yielding varieties. High yielding varieties because these are the high yielders. So when the yield is higher, then they are able to get maximum price from it. Their income will increase. But what happens in case of traditional varieties which have certain uniqueness? So traditional varieties are generally low yielders, but there are many good qualities like biotic and abiotic stresses, then some unique aroma, then other qualities like seed character or grain character, or some rice varieties have some unique medicinal properties also. But due to low yielding ability of these cultivars, they are reluctant to go for cultivation. So if we can increase the price, since it is difficult to increase increase the yield level of these cultivars, what we can do, if we can increase the price, then only farmers will be interested to go for cultivation of this particular varieties, and then only there will be conservation, there will be promotion of this product. So whenever we give the GI tag to a particular unique rice variety or traditional land variety, land races or like that, then it will protect the distinctiveness, the reputation of the rice varieties. And in that case, the farmers will be able to get some good income from the marketing of this product. It will give recognition to them. So that is why it is very, very important to go for GIS branding. And nowadays, our customers, whenever they see a GI tag, then they are able to know that yes, this is a unique rice variety, and we can establish the uniqueness by providing the history or traditional knowledge that is associated with the production process. So in this regard, I want to mention about the Kala Namak rice, that is a GI registered rice from UP. So history says that this Kala Namak rice has the blessings of Lord Buddha. So in the marketing, So I have seen in some of the packets, so there is the image of Lord Buddha. So this is the historical evidence. This is a traditional knowledge associated. So it has the Lord Buddha's blessings. So it is an aromatic rice. It has certain uniqueness in it. So this uniqueness will help the farmers to fetch premium price in the international and national market. So now rice biodiversity in northeastern region and the GI tag. So we all know that northeastern part of India is very rich in biodiversity. It comes under the 12 mega biodiversity hotspots in the world, and there are a lot of unique rice germplasm which have some unique quality characteristics, unique aromatic rice, then rice with medicinal properties, and so many things. But only 4 rice cultivars have been registered under the GI Act. So there are a lot of challenges, and if we see, so these are different classes of rice from Northeast India. Sali rice, so Sali rice, we can see that there are some bold seeded rice. The seeds are very bold, and this Sali group, bold seeded rice, these are preferred by the people who are the hard working, hard physical laborers. They prefer the Sali with bold seeded rice. Then Lahi means it is slender. It is medium, slender, medium grain size, and it is mostly preferred by the urban population. Then the third group is Bora. So if we see the Bora is, this is high amylopectin content rice. These are mostly preferred for making traditional snacks and also traditional wine. So traditional wine also plays a vital role in GI registration because we can register traditional wines as GI tag products. So Feni was the first GI tag traditional rice of India, traditional wine of India, and from northeastern region. So there is a traditional wine called Judima. It belongs to the Dimasa community. So our university, Assam Agriculture University, has facilitated the GI registration process of Judima traditional wine. It is the first traditional wine which is registered from northeastern region. So Bora rice is used to prepare the various traditional dishes.
Ma'am, last 2 minutes, ma'am, last 2 minutes.
Okay. Johar group is aromatic group. It is already registered above. It has the potential. So if we see some of the registered India, so we can see that here these are the list of some of the registered rice varieties. So these are the registered Joha and Sokwa from Assam. We facilitated this. This is the Judima. This is the wine, and then this is Fulam Gamusa. Then last, what are the challenges for GI registration in Northeast India? First thing is that lack of awareness. Our indigenous people, they do not know what is GI registration, what are the different benefits. Then there are a lot of products, but we do not know how to identify the products because we cannot we cannot go for GI registration of each and every product. Then lack of historical evidence is another important challenge because most properly documented in Northeast India, and particularly whenever we go rice varieties. Northeast India, and if we go for this, if we can the process comes up, we can ultimately it will.
Kargi Sharma, ma'am, I think some technical issue from your side. Please continue. Ma'am, is it audible?
I think she has stopped. She has left the room. Let's call the next person.
Yes, ma'am.
Next is Mr. Vaswa Sharma.
Ma'am, I think Kargi Sharma ma'am has entered.
Yes.
Ma'am, if you have any, Kargi Sharma ma'am, is it audible?
Sir.
Yes, ma'am. We have questions from my side.
Yes, sir.
Government of India through Department of Policy and Internal Trade, Promotion of Industry and Internal Trade, they are taking a lot of steps as far as
Yes.
the as well as giving awareness both through the ministry and other agency. They are creating more awareness. That is the case. Do you think that still the people from Assam and other northeast they should get more awareness on IP as far as the conservation of indigenous rice variety of India is concerned?
Yes, sir, you are absolutely correct. We are actually, there are very few awareness campaigns here, particularly among the rice producers, rice farmers. So actually in our area, northeastern region, the awareness on IP itself is very, very low. So when it comes to GI, it is further, it is, we can say it's very, very negligible. So there is a need to develop, increase the awareness among the rice farmers. Then only they'll be able to know if they come and know about the benefits of GI registration, and if they will get better price for GI tag rice, then only it will encourage them to go for production and marketing of GI tag rice, and it will help us.
Okay, Dr. Vijita, ma'am.
No, thank you.
Thank you, thank you, thank you.
Okay. Thank you. Thank you.
Ms. Varsha?
Am I audible, ma'am?
Yes. Please begin with your presentation. Sir, is she audible to you?
No, ma'am, she's not. No,
Vaswa?
Am I audible now?
yes, you are audible, ma'am.
Yes.
Okay, good morning, ma'am, and good morning, sir. Can I have the permission to share the screen?
Yes.
Yes.
Okay. Is my screen visible, ma'am?
Yes.
Yes, it is.
Okay. So, the topic of my today's presentation is patent law and the related challenges. Let me start with the brief introduction of intellectual property rights without consuming much of the time of this conference. Intellectual property rights, these are the exclusive rights that are provided to the owner or the creator of the original work. Intellectual property rights, it plays a crucial aspect in the modern economies, fostering innovation and creativity by encouraging individuals and companies to invest time and resources into research and development. Includes copyright, trademark, patents, geographical indication, integrated circuits, and much more. Now, let me talk about specifically, I want to emphasize on the patent law. Patent plays an important role in inventivizing the innovation and technological advancement by granting the inventors and their exclusive rights to their inventions. So the patent, the time period for the patent grant is 20 years, and it is granted to the exclusive owner that capable of being utilized by the general public, or it must be capable of industrial application. It must qualify non-test, novelty, utility, and non-obviousness. So all these conditions need to be satisfied to make any kind of invention to be patented in India. Just a minute, ma'am. Okay. So this patent system is, we cannot say that patent system many loopholes, and it is not without any kind of criticism. And critics argue that patents may sometimes hinder innovation, particularly in the sectors where patent tickets and patent roles can create barriers for new entrants and small companies. There are ongoing debates about the balance between between granting the exclusive rights to the inventors and ensuring accessibility to critical technologies and medicines, public health. Tracing back towards the history of Indian patent law, earlier in 1911, Indian Patents and Design Act was introduced, and it came into existence to give the exclusive right to the investors independently. And then after that, many conventions, many treaties like Berne Convention, TRIPS Convention, TRIP agreement, and many other treaties and conventions came into existence to improvise the law of intellectual property, especially the patent. Requirement for medications to be protected. Now, here the issue is that what I have observed in many of the researches that the patents are granted more to the foreign countries as compared to India, and especially in the field of medications, drugs, that is healthcare sector. Indian patent law need to be changed so that pharmaceuticals can also obtain such that there is a lot of trouble in conceding the licenses to drug enterprises. It is a difficult task to grant patents to these industries. The conditions outlined in Patent Act are not up to par and cover a wide range, making approval extremely difficult. So granting of patents is, in my opinion, granting of patents is very much complicated and a difficult task for Indians and Indian organizations or Indian companies or Indian educational institutions. India is is on third position in innovation and in the quality and scope of medication that are produced. But still, there are many cases, there are many complications that are going on nowadays. Another issue that is faced in the patent grants is that patents are generally granted more to US and UK companies as compared to India. Patents contribute towards the development of the nation, yes, of course, and therefore more innovation develop our country. More and more we get the patent grants, more will be the innovation, and then more will be the economy of the country. And जैसे जैसे economy will increase, वैसे वैसे the development of the nation will increase. So the grant of IPRs, it is not only about patent, but I am emphasizing more upon the patent because patents are very much important towards the development of the nation. It is very important, especially in healthcare sector. More and more innovation should be there in the medication so that we can treat many kind of diseases. There are still many kind of ailments for which the medications are not available. And in Section 3 of Indian Patent Act,
Vashwa,
there
last
are
2 minutes. Last 2 minutes.
So let me conclude. Section 3 of the Patent Act mentions non-patentable by introducing some kind of amendments, and the process to grant the patents must be less complicated in India, and Indian, especially women, as we have celebrated IPR and women this year. So women should be encouraged to for the grant of the patents, and more awareness should be spread among the Indians so that we can get more patents. Thank you.
Yes, thank you, Vashwa ma'am. We appreciate that you have explained about the overview of the patent system. Is it audible? Sure.
Yes, sir.
Yes.
Yes. At the same time, your topic itself is a patent law and challenges.
Yes,
When we read the patent system from 1883 to till now, there are a lot of challenges are there. When after 1950, 1990, even 2000, even 1994, if you start even after 2005, like that. Vashwa Sharma, as far as the international conference is concerned, what we expect that, like an academician from you, that you have to come up with a lot of the recent and contemporary issues as far as the patent challenges are concerned, so that the young mind as well as I think students and there is scholars will know more about it. Vijita ma'am?
Yes, sir. Like have asked, you have suggested that awareness should be made. So I want to know at this juncture that what can be the steps that can be taken by the academicians or the academic institutions in order to spread awareness regarding the intellectual property rights.
Ma'am, different training programs, conferences, seminars, group discussions can be introduced in the course curriculum of the students so that the college students can also get aware of this.
So can we include this in the legal aid program also? Like
Yes, ma'am,
legal
that
aid
can
is one of
be.
the.
Yes, ma'am.
Hmm.
That can be that we can introduce, like we organize legal aid camps in various villages and various remote areas. So we can introduce the right, so that at least some of the backward population must be aware that what is intellectual property
Clinical
right.
teaching can also be given. So
Yes,
that, like one of our presenters in the beginning talked about the farmer's right. So
yes,
we can create, we can have some kind of awareness programs with the help of the legal
yes,
aid
yes,
cells of the academic
yes,
institutions.
yes.
Thank you.
Okay, thank
Okay,
you.
thank you.
Dear,
Next is
dear
Mr. Ashwini, ma'am, Ashwini A. Kulkarni.
yes, ma'am. So instead of Ashwini Kulkarni, there's a slight changes. Um, the number 7, that is Dr. Ashwin P. shall be presenting now, and
Okay,
after him,
Okay.
Ashwini Kulkarni shall be presenting.
okay.
Number 7, Dr. Ashwini P.
Good morning,
Okay.
respected chairpersons. Thank you for considering the request. And my topic for presentation today is patent laws and enforceability, a global perspective. As an effective means of enforceability of patent law at the global level, the harmonization of the global law, the harmonization of the patent law at the global level is the need of the hour. The efforts were not new. From the past 100 years, the efforts regarding the internationalization of the patent law has been done. But despite of these efforts, it is not yet to be achieved, as it is needed for the protection of the IPR worldwide, which is in turn critical for the international trading of goods and services. They operate under the patent as well as copyright and trademark. So my presentation is basically concerned with looking into the current issues on the enforceability of the patent laws by taking some of the positions in the developed countries as well as by focusing on the position of the developing countries. So, as we are all aware that a patent system extends to property rights to new technology and is a government grant monopoly for certain duration on a particular invention for certain years, after which it will come to the public domain. So there is a reason, as I said, one of the effective means to enforce the patent law at the global level, or in general, if we say that is one of the initiative for the effective implementation of the patent law, there are two reasons. As the nations are proceeding from the industrial based economy to information based economies, there is a necessity of protecting the intellectual property rights, which deeply affects the trade issues. And the second reason is by adopting this method, the administrative burdens and the redundancy of the prosecuting of international patent applications amongst the participating nations can be reduced. So some of the initiatives have already been taken, but they have their own drawbacks with respect to the spheres in which they operate. Some of the examples of such global initiatives or international initiatives are Paris Convention, which came out with the protection to the investors, but it has failed to provide the standards of substantive patent rights. Secondly, if we take the example of Patent Cooperation Treaty, which constituted again an important step towards rationalizing the application worldwide. But the failure on the part of it is in terms of harmonizing the patent system, which would have resulted in the international patent protection. And subsequently, there were discussions under WIPO, that is World Intellectual Property Organization, wherein the United States, did not agree from shifting from first to invent system to first to file system. So thereby that conference came to an end. Subsequently, the TRIPS, that is trade related the unrestricted trade and technology transfer. So also, when we talk about the goods and technology, since they constantly flow across the national borders in today's world, the impact of the patent protection is very much increasing. And also we can witness the increase of the world trade and multinational corporation growth, the problem exists of obtaining uniform patent protection extending beyond the national borders. So in this concern, the primary quest is for the harmonization of the patent law so that it can be effectively implemented. To focus on the advantages of this particular system, it is very advantageous from the point of view of the countries which are expecting for the patent protection by way of having a uniformity in filing procedures, secondly uniformity in examination and grant procedures, uniformity in terms of interpretation, remedies and enforcement. However, when we take the example of United States, which took an initiative by way of bringing amendment to its United States Code as a result of the decision given by the US Supreme Court in Deep South Packing Company versus Latham Corporation, wherein it has been held that where the US has made an attempt to exert effective patent enforcement in terms of extraterritoriality with the amended code. Under such circumstances, it was viewed as a trade barrier by the international community. So when this is the scenario, there are the hurdles in terms of enforceability of this patent protection globally. So another important or major issue is first to file controversy of United States, wherein other countries of the world operate on a first to file system. So these conflict allows for a situation where the same invention, the patent for the same invention can be awarded to different parties in US comparably with that of the other countries of the world. So the US patent system, if we take as an example, it will be examined on the basis of novelty, obviousness basis in a formal ex parte proceeding by the US Patent and Trademark Office. Whereas comparably with that of the other countries, in other countries, the position is that the patent application simply publishes after some period of time and is never examined except as to non-substantive formalities. So thereby, there are benefits when we talk about the harmonizing of the patent protection in terms of global level, that when we talk about first to invention step, comparably with that of first to file will be more beneficial and it acquires a superior position, as well as it diminishes the cost of the patenting process of the party, not only of the parties and of the society. And there will be significant advantages when it comes to the question of small companies and independent inventors with respect to the complications, costs, and providing invention. So in this way, even if we take the example of Europe, also there are systems which are in conflict. To overcome this situation, my findings is to establish a system in terms of setting up office which is called as a world patent system, and by adopting 12 dozens of language for the effective functioning of this world patent system, which can function parallelly with that of national level, as well as by way of establishing a world patent court by having representation of the experts from the various countries, rather giving the opportunity for the adjudication to the nationals of one particular country, so that there can be a fair and appropriate adjudication of the patent applications and any disputes pertaining to the. So this topic by saying that though there is a difficulty in implementation of this condition of harmonizing the patent, but it is not impossible. So under such circumstances, this major step is necessary, as there is a necessity in terms of international trading of goods and services. The patent harmonization is one of the major steps towards the current international patent law protection. That's all with my presentation, and thank you for the opportunity.
Thank you, ma'am. Thank you, Dr. Ashwini, ma'am. We have a few questions since you're an academician. And the topic itself is a patent and its enforceability, a global perspective. And basically, the patent system in each and every country is in a territorial in nature. Territorial in nature, and each and every country they have a right to follow the minimum standard. Note this point, ma'am. Minimum standard. Even this debate has started in the era of 1883, then 1886, even during the PCT before that, also from 1986, and there are a lot of discussion and debate that whether one size will fit for all. If that is a case, do you think that the world patent and setting parallelly an office, and also we have already the system like we have a system PCT, we have a system called Madrid protocol, like that, in order to facilitate only for that purpose. Do you think that the world patent is possible? And because when you go to the global perspective of an IP, particularly there are the vast differentiation between the developing country and the developed countries and the least developing countries. In such a situation, do you think that can you bring all, otherwise you give the autonomy to the each and every country, but that country autonomy taking decision as far as the IP is concerned should not substand the very strong foundation of an IP?
No, sir. According to me, if we go with this unified system of protection, by having the fair arbitral panels, there are possibilities to, irrespective of the conditions. Even I would have spoken about the developing countries
Yes,
because
yes.
of the paucity of
No
time. I
problem.
couldn't. This is an initiative where, as I said, the three aspects: that adoption
Yes.
of the international languages, the establishment of the World Patent Court, and by way of adopting World Patent System with the representation of the various countries to ensure fair implementation of the same. Such efforts are possible, even though the laws said to be territorial in nature. There are some IP rights which goes beyond the
No.
territories also. Particularly since I was
I
talking
do
about
agree, ma'am. I
patent.
do agree. The point is very simple. That when each and every country they have a rules and regulation. Take an example, I will tell you the way in which you are talking about enforceability. In India also we have enacted legislation of 2007, intellectual property court reports enforcement rules. I am telling about one example. When we have a rule called 301 report by the US, time and again they used to notify that which country which strongly follow the enforcement of IP, which country is very liberal about it. That is an indication whether they are very liberal as far as the enforcement is concerned. That is what I would like to ask you to say, that this will be approximate methodology has to be followed as far as the enforcement
That is
aspect is
what it
concerned.
is up to the countries, sir. When it comes to international law, as we all know, it is up to the member countries to adopt the measures. But
Okay. Okay, ma'am. Thank you. I would like to know, madam, Dr. Rita, if you have any
I
questions,
feel,
yes.
sir, that the presenter wants to say that if there is an international violation of patent, so who is going to deal with it? So that's why she wants to say there should be an international patent court which should specifically deal with the patent violations at the international level.
Yeah,
So
that is the reason I'm
because the world is a global village, we are in an era of globalization. Therefore, violations can be worldwide. So that is, I think, she wants
yes,
to
yes, ma'am.
talk
That is the reason why
about
normally
that.
even in India also they used to say trips is nothing but a
Yes.
tricks.
Thank you.
Thank you, Dr.
thank you for
Ashwini,
your
ma'am. Thank you
question.
for
Next,
your presentation.
Thank
Thank
you.
you, ma'am. Thank
Thank
you.
you, ma'am.
next is Ashwini.
Yes, ma'am.
Yes, Ashwini Kulkarni, madam.
Yes, ma'am, you
Yes,
are
ma'am.
audible,
Am I
ma'am.
audible? Okay. Good morning, everyone, respected chairpersons and my fellow scholars. My topic for paper presentation is an inquiry into the infringement of trademark and copyright laws of India in cyberspace. As per the discussion about the previous presentation also, I would like to throw light upon certain concepts. Look, I'm not here to explain the concept of intellectual property, what is trademark, what is copyright. I just have introduction about my paper presentation and what I have mentioned in my paper. Basically, comprises of the concept of IPR, then the concept of cyberspace, which we are living in a society where there are no geographical limits. Along with that, I have mentioned certain case laws also, which will be dealing with these issues. Similarly, I have introduced the concept of copyright also, and the copyright issues in cyberspace, which states linking, catching, plagiarism, protection of database, and protection of computer software. Along with all these concepts, I have mentioned certain concepts of cyberspace, cyber laws, which will be dealing with the IT Act, and certain case laws also. As a cyberspace, we can define cyberspace as a virtual space where the people, they are interconnected, and this is an interconnected space between the networks of the computer system. In my paper presentation, I'll be introducing certain international regimes related to the protection of IPR, which can be the TRIPS agreement, which will be dealing with the protection of the programs for copyright. Then WIPO, that is protection for the IPR worldwide, that is interstate or between the nations also. Then UDRP, that is the Uniform Domain Name Dispute Resolution Policy, which will be dealing with the trademark issues of domain name disputes. And the last one is the Berne Convention, where the International Union for Protection of Literary and Artistry Works includes. My paper presentation mainly focuses on the jurisdictional issues we are facing in India, since the law is non-existent till 1999 in the Indian society. There are actually, I should say, there are no punishments included in the Indian legislation for the cyberspating and IT Act. There is no legal compensation regarding the cyber crimes in for the violation of online trading, electronic transactions, or the violations of the IPR rights. Basically, coming to the conclusion, apart from all these discussions and all, I came to the conclusion that few people in India, they are unaware about the intellectual property right, basically. And then if they are aware, but still they are not aware how to proceed, or how the legislation is working in this field. Networking lead to the concept of cyberspace, but many issues arises due to the security of cyberspace. Online IPR violations has become one of the prime sources of direct and indirect for economic losses in our country, and is also harmful for the development of the country. There are no special jurisdictional rules in case of IPR infringement over the internet. We are having ill-equipped laws, no sufficient case laws to study for the research, and as the law is still developing, it is in the nascent stage. IT Act in the Indian legislation does not provide any provisions in respect to the cyber crimes related to the violation of IPR, though computer programs are protected under the Copyright Act. But still, the Trademark Act and Copyright Act are silent on the issues of online infringement. Then, though which aspects are yet to include in the development of IPR laws in cyberspace in India. There is a need of specific provisions which regulate the IP rights in cyberspace, and the present Indian legislation on cyber laws does not have sufficient provisions to problems relating to IPR and cyberspace. Though international regimes do provide laws to the infringement of IPR, are helping in e-commerce and e-businesses, but still there are no proper regulations in India. So there has to be certain regulations which should be developed. And my study, it states that what do we have, what have we learned, and what needs to be done. So these are the certain concepts I have mentioned in my paper presentation. And with this, I end my presentation.
Thank you, Ashwini ma'am. Thank you.
Yes.
And I have a question as far
Yes,
as
sir.
the trademark and copyright in cyberspace is concerned.
Okay.
Time and again, we have amended both trademark law and also copyright law. And time and again, we have amended IT Act also to try to bring the tune and also to give the protection to all kind of violations which happen through the virtual platform. And as far as the copyright is concerned, we have a few provisions for implement of copyright and trademark also. And as far as the jurisdictional issue is concerned, what you want to say about it? Even if you are able to trace the concrete or an activity. Do you think that the effective implementation by way of conviction is possible, or do you think that we can easily trace out?
Sir, as it is a limitless network of internet, it's not easy to trace, but still there has to be certain strict provisions in our legislation. We don't have that. I would like to tell you something. When I am going through the research for these topics, I find out we are having the first cyber squatting in Indian case law, that is Yahoo Inc. versus Akash Arora. It was in 1999
Yes.
Delhi High Court case. Till then we don't have any legislations, any laws regarding this. And after 199 after 1999 we introduced the IT Act, then we started thinking about that. And the concept of online infringement is quite new to our legislation. We are still developing, and that is the reason it is we are having many problems in the cyber crimes and cyber law departments. That is the main reason, I should say.
And one more thing, madam, you have, yes, good. Yeah, one more thing, madam, you have mentioned about all.
Yes.
And I think time and again, both state government and central government, in case of all kind of trading and other things, they are advertising it time and again. That is an issue as far as India is concerned. And we have a provision in the IT Act also. What do you want to say about it? Do you think that still there is a lack in case of enforceability?
Sir, not only government is lacking in enforceability, it is awareness about the matlab we should deal with the awareness of the people also. We should aware the people ki what they have to do, what they shouldn't do. Because not only the government is working in its place, but it will work only if the people will support them. No, the government is sending the messages that don't reveal your OTP or else, but still some ignorant people, they are still doing the same thing again and again and again. Though the government is enforcing, but for the better implementation the people should be
Okay, in
aware
which way
also,
will
no?
okay, ma'am. In
They
which way
should be
will you connect
cautious.
to the trademark and IP as per this one?
Sorry sir, I'm
No,
not
in
getting
which
your
way will you
question.
connect this electronic transaction with the trademark and copyright?
Sir, actually, I was dealing with all the not only
Okay,
the
okay,
transactions but all the issues in the cyberspace related
okay.
to the infringement of
Thank you, ma'am.
trademark and copyright.
Dr. Vijitama.
Basically, the
Yes, ma'am.
cyberspace, the infringement, whatever the frauds are being done in the cyberspace and related to the intellectual properties and its related
Yes,
rights
ma'am.
are basically the copyrights which are being infringed, and the main problem of the academics which we are dealing with, the plagiarism.
Yes, ma'am.
So that
Yes, ma'am.
is the main focus of how the infringements are being done on the cyberspace. And as we all know, cyberspace is unending.
Yes, ma'am.
And like you said that people should be made more aware, and people are making mistakes, they are non-serious. But how do we expect the uneducated class who is having a mobile in his hand to be very much aware about what he has to do and what he not has to do? So that is the point to think. We should like iterate
Definitely,
upon
ma'am.
that
That's
also.
why I mentioned the point that in the country like India, which is a developing country, the law is still in the nascent stage only. It is still developing. It is like a small baby. We should take care how we take care of a baby. Ki bhai ye karna hai. This should be done. This should be not done. So that is the case. The law is also in a nascent state in the country. So we have to take proper precautions, we should say, or proper amendments for the enforcement of this law. We should make people aware. जैसे मैम we know कि कुछ सालों पहले we are having issues of polio. When once Amitabh Bachchan came on the television and he said कि भाई you should have the polio dose for the kids. So then people get aware कि हाँ Amitabh Bachchan ने कहा
Amitabh
दूंगा
Bachchan
आपको
is
तो मैं.
still coming for RBI.
Yes, ma'am.
Still
Now it
coming for
started
RBI on
because
the
the government is
television.
thinking that people listen to Amitabh Bachchan. That is the reason. So these are the I should say the amendments the government is making from their side. So it is the duty of the people also. So some way or the other, we all are dealing with the situation and we all are trying to cope up with it.
Thank you, ma'am. Thank you for
Yes.
your
Thank you, sir. Thank you, ma'am.
ma'am. I invite the next
Yes,
person.
welcome. Next is Dhayanta Kumar.
Good morning, everyone. May I share the screen?
Yes.
Thank you. A very good morning to everyone. I'm Dhanata, pursuing law from Dogra Law College, Jammu, JNK. My topic for today's presentation is patent law and challenges. Basically, the intellectual property rights are growing, and at the same time, the patent laws are growing at the wider aspect with its main purpose to disseminate the scientific knowledge and to promote innovation. But the recent trend shows that there is a declining rate of innovation. If we come to the introduction to patent right, patent is exclusively considered as an exclusive right of the individual who invented something, and at the same time, in order to protect that invention, one has to overcome its challenges. Before I proceed with the challenges, I want to tell you about the basic purpose of the patent right. That is, it basically encourages the inventor to do more and more invention, and it protects the interest of the inventor, which is required for its goodwill and the monetary gains of the inventor, and it simultaneously builds trust to the inventor that their invention will remain safe with him or her. So if we talk about the laws which are made both at the national level, specifically in India, and at the global level, we see about the global level. So basically there are the Patent Cooperation Treaty. PCT is basically an international treaty with approximately 159 countries. It basically provides us with the information about the treaties which are administered by WIPO, World Intellectual Property Organization. One and the biggest benefit, if we talk about the PCT, the biggest benefit about the PCT is one have to file the application in the PCT, and one can prevent it from filing in the different countries with different procedure of their patent. Let's come back to the Indian Patent Act. Before coming to the Indian Patent Act, that is the National Patent Act 1970, enforced in 1974 with 23 chapters and 162 sections. It extends to whole of India. According to this, invention means any new and useful art, process, method, or manner of manufacture, machine, apparatus, or other article, substance produced by manufacturer, and includes any new useful improvement of any of them and an alleged invention. Basically, if we talk about the examples of the patent rights, these are for example, Alexander Graham Bell invention to the telephone. Now, if we come about the historical background of that, these are basically the Patent Law 1856, the Patent and Designs Act 1911, Patents Act 1970, and Rules 1972, Patent Amendment Act 2005. Now, persons which are entitled for the patents, that is the first true and the first inventor, his or her assignee, and obviously the legal representative. The India, as a member of the WTO, World Trade Organization, is obliged to align with its IP rights and is in aligned with the TRIPS agreement. TRIPS agreement, basically it is trade-related aspects of intellectual property rights. Popularly, it is called as trade agreement. Our Honorable Prime Minister, Shri Narendra Modi, made a remarkable change in the field of the IPRs just to meet the objectives of it. What he did, he basically made a CIPAN, Cell for IPR Promotion and Management, to meet the objectives. In this, he appointed the examiners just to clear the backlog of the patent and the trademark applications, and at the same time appointed a number of facilitators to encourage the persons to file the patent applications. I also want to take your attention to the positive developments. According to the annual report of 2017-18 issued by Indian Patent Office, in this, the increase of 5.3% in filing as compared to the previous year, increase in examination rate by 108.2%, number of patents granted increased by 32.5%, domestic filing of patent application increased by 32.5% as compared to 29.2% in 2016-17. India also a signatory to several IPR-related conventions, that is the Budapest Treaty, Berne Convention, which governs copyright, Paris Convention for the protection of industrial property, the PCT, Patent Cooperation Treaty of all, which govern various patent related. The international patent law, I have already discussed it. Now, PCT is necessary. Why it is necessary? Basically, firstly, it prevents the filing of the applications in indigenous countries. Moreover, it brings the world within reach. It removes separate applications in different countries, provides strong basis to the user for patenting decisions. So this is the process which I have written here. PCT filing application, the Patent Cooperation Treaty filing procedure.
Last 2 minutes, ma. Last 2 minutes.
Okay.
Proceed.
In the local application, filing the PCT application, checking for defects, as I am having with the less time, so I will just pronounce the points. International search report, international publication, international search, international preliminary report, international fees. Now, coming to the challenges. The biggest challenge is in the invention of the pharmaceuticals. Basically, what is happening in USA, there is an increased conflict. There is an increased conflict between the buyer and the industry about related to the specific drugs. Who is getting impacting with it? Basically, who is at the loss? That is the general public, because they are prohibited from taking the medical assistance of those specific drugs. Next emerging biggest issue is in the field of the biotechnology, because in biotechnology there is a major conflict is where what can be patent and what cannot. Since copying is much more prevalent in this sector, so more and more biotechnology companies want to get their invention before it gets copied to another. Another biggest challenge is in the field of the public health. In this, the main objective is order to maintain the better public health is to strike a balance between the inventor's authority and to develop a method of technology to advance healthcare and how it to use to serve the needs of the general public. These are much more examples of this challenges. If we talk about the solutions about the patent problems, unfortunately, there aren't clear solutions to many of the aforesaid mentioned problems with the patents. Patent laws are dynamic, however, legislators will continue searching for ways to reward inventors while allowing innovation to flourish. These are, I have written some of the cases, both at the global and the national level. And so these are some of the cases like applicant versus European Patent Office and many more. Before concluding, I want to say a famous saying by Charles H. Dewey, a commissioner of the US Patent Office. He said, everything that can be invented has been invented. Thank you.
Thank you, Dhanita. Dhanita, I should appreciate you that being a student you have come forward for presentation in international conference. But in international conference, there is a standard rules and regulations to be followed at the time of presentation. Normally, we have to tell about the clear clips about attention of the topic that you have done it and referred it. But as far as the challenges are concerned, there are so many challenges are there as far as the patent perspective is concerned. You explain about it, particularly you have referred about the public health aspect. You have heard that even during COVID-19 also, both India as well as the South Africa, both joined together and appealed before the TRIPS Council as far as the TRIPS waiver is concerned. And do you want to say that despite the fact that we have a provisions under the TRIPS agreement Article 4, that during medical emergency and external emergency, may take a decision as far as the IPR policy and other related matters, including protection. Do you want to say anything about it? As a challenge.
About the patent,
you want to yes,
the
public health aspect which are referred as a challenge.
Basically, public health, what is happening that the patent holders basically serve as a catalyst, as it basically wants the patent holders to do more and more expensive financial installments just to maintain the necessary facilities of it. Because many businessmen, if you talk about if I give the example, basically many businessmen in the country take more and more invention, do more and more invention, and take more and more patent rights just to maintain his dignity, just to maintain his aura in the field, according to me.
Okay, and one more thing you have referred as far as the biotechnology is concerned, starting from 1950, you referred, we have a strong, the departments and also in order to promote as well as the draft the policies as far as the biotechnology is concerned, is the fact that previously there was an issues with regard to the science and technology and department of biotechnology. Now, even for an IPR aspect, we have a rules also as far as the biotechnological invention is concerned. Do you want to say something that still there is a challenges as far as the biotechnological related innovation is concerned?
According to me, biotechnology has many more challenges and I have mentioned one since copying. Copying is much more prevalent in the field of biotechnology because there are many more companies which want to get their invention, which want to copy, which want to do the invention. So, for example, the medicine for cancer is still not actually present. Yeah, for the medicine for AIDS, it's still not present. So, whichever the company which make it, there are high tendency that it gets copied with another.
Okay, thank you.
Thank
Thank you. Dr. Vijita ma'am.
Sir, no question, sir.
Okay, thank you. Thank you.
Next. Next is Manjunath.
Dr. Manjunath.
Sujita. Dr. Sujita.
Yes, ma'am. Shall I start?
Yes.
Is the screen visible, ma'am?
Yes.
For centuries, cultures throughout the world have used indigenous technologies to navigate life's complexities. From navigator priests in Micronesia to mystics in India, vast sums of knowledge are available if we but recognize it, said Elizabeth Lindsay. Good morning, everyone. Welcome to today's presentation on the topic traditional knowledge and folklore, the striking need to preserve. So to start with, as you all know, India is a nation that is rich in folklore, indigenous practices, traditional knowledge of plant varieties, their medicinal values, recipes, dance styles, etc. In preserving them comes the role of intellectual property rights. With that, we'll move on to the meaning of traditional knowledge and folklore. So as per Article 8, Subclause J of the Convention on Biological Diversity, traditional knowledge refers to the understanding, innovation, and customs of local and indigenous cultures around the world. Whereas in case of folklore, in a traditional society, it can generally be found in a variety of media, such as music, dance, or any other performing arts. Secondly, the history and mythology, followed by designs and symbols, and lastly, the traditional crafts, skills, and artwork. Having said that, we'll give a glance over reasons as to why it should be preserved. Basically, as a significant intangible asset, it aids in the creation of beneficial practices, sustenance of connection between people and their custom, and further, in order to stop unauthorized and commercial misuse of the knowledge, it must be preserved. So, with that, let's see the existing legal framework. So looking on to patents, according to Section 3, Subsection P of the Indian Patent Act, traditional knowledge cannot be protected, which says that an innovation that effectively duplicates or aggravates previously known qualities of a conventionally recognized component is not an invention and not to be patentable. Section 25 and 64 of the Indian Patent Act provide certain grounds for revoking patent application for protecting traditional knowledge. However, IP protection can be pursued if there is a significant modification to the present traditional knowledge that enables the innovation to meet the requirement of the Indian IP legislation. To avoid patent grant to traditional knowledge in India, an initiative has been taken to document and publish all the traditional knowledge by e-library, and such e-library is called as traditional knowledge digital library. With that, I'll let my co-author continue.
So good afternoon all. Moving on to traditional knowledge digital library. In early 2001, India took the initiative for the development of TKDL to overcome the difficulty in documenting historic and traditional knowledge. It makes patent search easy by providing information that are not easily available. By this, we can prevent the granting of errant patents. So here are some judicial struggles faced by India relating to traditional knowledge. Moving on to the neem case, here the timber exporter got clearance in US for controlling fungi on plants with emanations from neem seeds. The NGO and Indian farmers proved that this same technique has been used in India for centuries. Then the patent was revoked in favor of farmers. And when moving on to the turmeric case, here the two US-based Indians were granted patents for the use of turmeric for wound healing. India filed a re-examination for the same. Their claim was supported by documentary evidence of traditional knowledge in Sanskrit texts. Then the patent was revoked. Moving on to the last case, the basmati rice case. Here, a patent for basmati rice was granted by USPTO to American company, and the company claimed that they invented certain novel basmati lines and grains by interbreeding with another crop. India made an appeal and submitted its evidence, and as a result, the company took back its claim out of 15 claims out of 20. And the company also took back its claim on the name Basmati. Over to my partner.
So to continue with the geographical indication, which is the most effective method of traditional knowledge conservation, although GI protection is only effective for 10 years, it can be renewed numerous times to provide protection for a whole time. Article 22 to 24 of the TRIPS agreement lays down minimum standards for the protection of GIs. For example, the Tanjavur paintings of Tamil Nadu, Bastard Ironcraft from Chhattisgarh, Hyderabad Halim from Telangana are all products arising from traditional knowledge, strengthen the economic capabilities of local communities and enable them to preserve such traditional knowledge. And moving on to the trademarks. So through the Trademark Act of 1999, indigenous products, even agricultural and biological products, can be protected through awareness programs. Indigenous communities can be made aware of the fact that the trade
Hello.
Sorry, sir, I will continue from where she left. Moving on to plant variety. Here, the traditional plant variety and farmers' rights plant Act 2001 is the Indian sui generis concept. It oversees the issues of protection plant varieties and farmers' rights. It also safeguards the conventional farming methods and traditional range of crops.
Last
but
1
it
minute, no, please wind up.
does not deal exclusively with the traditional knowledge, and corporate has also got issues in preserving in protection of traditional knowledge, like there is the issue of no single author, and the folklore will fall into public domain once the limitation period has got expired. By these reasons, we can state that corporate laws are not sufficient for the expression of folklore and traditional knowledge, and we have got recommendations from NGOs and academicians to inculcate since WTO fails to satisfactorily protect traditional knowledge, and the IPR laws are inadequate in nature as they focuses on individual rights, whereas traditional knowledge is collective in nature, and generally sui generis law means something of its own kind. In India, it was done in traditional knowledge and traditional cultural expressions by morphing certain aspects of existing intellectual property to balance the unique characteristics of traditional knowledge. Indian Parliament has passed sui generis laws such as the Biological Diversity Act 2002, and Plant Variety Protection and Farmers' Rights Act 2001. So I would like to state some other recommendations. So the traditional knowledge related intellectual property protection is currently covered by a number of international legal frameworks and instruments, and this should be well informed and regulated in a stringent manner. It's crucial to ensure that patent examiners are made aware of the traditional knowledge that has already been recorded in databases and print media. Traditional knowledge should only be included in databases if it is already in public domain or if informed consent has been obtained. Obtaining these data is expensive or time-consuming process. A wider definition of folklore is needed than what is provided by WIPO. A thorough national level development plan that strengthens preservation of traditional knowledge and addresses issues must be enacted. Over to my partner.
Am I audible, sir?
Yes, you are audible. You can conclude, please. Already you're running out of time.
So to conclude with the advent of globalization, the specific topic of traditional knowledge has come to great attention. More focus is needed on folk traditions as they intertwined with cultural, economic, and social parts of the society. The only system to safeguard them seems to be intellectual property. With the enactment of appropriate legal provisions, their insertion and awareness among the traditional societies, we can preserve our right from commercial exploitation and unauthorized use. Thank you.
Thank you, Sujata and Sophia. And I have only one question. As far as the traditional knowledge and folklore is concerned, we have a lot of issues both in South India and the North and Northeast. And do you have any cases, because a lot of issues are coming out as far as the traditional knowledge is concerned? We have a strong system which we have followed from 1883 even through the convention itself with regard to the dance and other literature and artistic works and all. Do you think that we have to follow any the law which is already there as far as the traditional knowledge is concerned? Do you think that US and other countries we have a legislation particularly for traditional knowledge? Because we follow a lot of the options and ways and means in order to protect the TK, both the biodiversity, plant varieties, and also cooperate like that. If that is the case, which model would be appropriate as far as the India is concerned?
So if we see on a global, see at the global scenario, we don't actually know how it is in US. But if we take the case of turmeric, they have already patented the medicinal use of turmeric. And once again, we fought for it and we got, and that is also only the case of defensive protection.
Yes.
We don't give it positive protection. So in such case, if we take the case of India, we currently don't have any provisions, and the insertion of novel ideas like TKDL, traditional knowledge digital library, or so traditional knowledge traditional knowledge resource class, and through such novel steps, and also with the influence of countries in which steps have been taken, we can move forward.
Thank you.
Thank you, sir.
Dr. Vishtama?
Can you please tell me regarding what is the defensive mechanism protecting this traditional knowledge?
So in case of protection, there is basically two types. It is positive and defensive. So in case of positive mechanism, it gives rights to the holders and protects any other person from using or violating their IP rights. Whereas in case of defense mechanism, it doesn't provide them with rights, rather it stops people from using it against their own.
Okay. Thank you.
Thank you.
We may invite you next.
Dr. Rupa, actually I'm running short of time,
Yes,
but there is a plantation program in my department. So in Uttar Pradesh, the government is holding a big plantation program today. So around 30 crore plants should be planted. So there is a plantation program to be starting by 12 o'clock in my
we will wind
department.
up. Before that, we will wind up.
So Dr. Rupa.
A very good afternoon, ma'am, to the respected chairpersons and to the fellow presenters. I'm Dr. Rupa from BMS College of Law, Bangalore. And today I'm here to present my paper on the topic correlation of intellectual property law and biodiversity issues, challenges, and perspectives. In my paper, I have discussed the relationship between IP law and biodiversity, the challenges faced by biodiversity, protecting the traditional knowledge through geographical indications under IP law, intellectual property and convention on biological diversity, and lastly, the impact of IPR on biodiversity. And I would be concluding my paper with a few suggestions. Coming to the meaning of intellectual property law, as we have been discussing since morning, IPR as such is granted to the inventors and the originators to ensure that some sort of protection is afforded to them because they are sharing their knowledge, ideas, inventions with the world. And they are protected from the imitators from commercializing the products and making profits out of the same. Biodiversity as such includes various living organisms and the diversity in the interspecies as well as the intraspecies. And both of these concepts are very much interdependent because we see that the inventions and the products are derived from the resources which are present in the biodiversity. Now, coming to the relationship between biodiversity and intellectual property, IPR as such serves two purposes. Firstly, we know that the products which are made from the particular raw materials which are used from the biodiversity is one aspect, and the other is those products which are actually derived from the conventional wisdom or the traditional knowledge, which is actually protected by the geographical indications. We know that there is a huge demand for the herbal and the organic products. The derivatives made from the biological diversity are particularly helpful in the agricultural sector, reducing the crop failure or increasing the fertility of the soil and all such things. And also there are new plant varieties which are introduced because of the use of technology. And we should now understand what is the major challenge that is faced to the biodiversity because of this. The benefits from the commercial use of the products have been not shared with the local communities, but it is exploited by the commercial enterprises for their benefit without sharing the benefits with the local communities, which continues to be the major challenge as far as biodiversity is concerned. Now, protecting the traditional knowledge through the geographical indications, we know that traditional knowledge as such is an inextricable part of the intellectual property, and the geographical indications as such is identified, because the product whichever we are getting from any particular geographical area is identified because of its location, the humidity, soil, and from where the product is coming. And that way we see the geographical indication as such is a major instrument in the hands of the local communities, wherein they can endorse their products, they increase the brand value, and there will be better market for the goods, and it also leads to the socio-economic empowerment of these local communities. Now, coming to intellectual property rights and biological diversity, there are four important aspects in the convention which are related to the protection. That is equitable sharing of the benefits, the transfer of technology, the conservation of the biological resources, and the traditional knowledge. The major object of the Convention on Biological Diversity as such is to stop the unfair exploitation of the biowealth and the traditional knowledge of the developing countries. So firstly, the access to the fair and equitable sharing of benefits. The provisions are very much clear under the convention that there has to be sharing of benefits with local communities by the commercial enterprises. And the state parties should have proper legislative and administrative framework for the same. Secondly, coming to the preservation of and respect for the knowledge, innovation, and practices of indigenous and local communities. The traditional knowledge as such is always conserved through the informal and the collective process. There are actually two views with respect to it. One is that the IP is actually contributing to the growth of biodiversity, and the other is just opposite to that. And the transfer of technology is the technologies which are actually relevant to the conservation of the biological diversity. The developed countries should be sharing with the developing countries the technology on most favorable and fair terms. And lastly, conservation and sustainable use of biological resources. So although these provisions are very much present in the convention, we still see that there is a lack of, there are a lot of loopholes in this. And I have made few findings on the basis of that. Firstly, although there is, intellectual property rights, and then we have the geographical indications, the conventions, and all this, we see that the intellectual property law has actually led to a decrease in the genetic varieties. So it is actually leading to the genetic